I was in my chambers of the federal courthouse, reviewing case files late in the afternoon, when my phone rang. It was my grandmother. She was crying, shaken in a way I had never heard before. Through sobs, she told me that two men claiming to be county officials had come to her door and served her with eviction papers. According to the documents, she had 72 hours to vacate the home she had owned for 53 years or face forcible removal by law enforcement. My name is Michael Beaumont. I am 48 years old and serve as a United States District Court judge for the Northern District of Oklahoma. I was appointed to the federal bench 7 years ago after spending 19 years as both a prosecutor and a private attorney. I now preside over federal criminal and civil matters, carrying the authority and responsibility that accompany a lifetime appointment to the federal judiciary. My role demands absolute impartiality, disciplined legal reasoning, and the careful exercise of judicial power with restraint and precision. That role also means I understand exactly what legal procedures must be followed for a lawful eviction. After reviewing thousands of filings over the course of my career, I can recognize fraudulent legal documents almost instantly. I am not physically imposing or confrontational, just an average-built man with the academic bearing of someone who has spent a lifetime in courtrooms and law libraries. But I possess federal judicial authority that most people never fully grasp until they encounter it firsthand. My grandmother, Dorothy Beaumont, is 84 years old. She is a widow who has lived in the same modest house in Tulsa since 1971. She raised my father and his siblings there and has fiercely guarded her independence despite her age. The idea that criminals would target her, terrorizing her with fake eviction papers and threatening to remove her from a home she had lived in for over 5 decades, caused something cold and methodical to settle over me. It wasn't emotional outrage. It was judicial resolve, rooted in the knowledge that the full force of federal authority exists to stop crimes like this. Nothing in my 7 years on a federal bench had prepared me for how quickly and decisively that authority could be mobilized when someone attempted to weaponize fraudulent legal process against my own family. I told my grandmother to remain calm, not to sign anything, and not to pay anyone a cent. I assured her I would be there within 30 minutes. I informed my clerk that I was leaving due to a family emergency and drove straight to her home in Midtown Tulsa. Already assembling my response with the same deliberate legal analysis I applied to every matter before my court. When I arrived, I found her seated at the kitchen table, a stack of official-looking documents spread in front of her. Her hands trembled as she struggled to read the small print. The paperwork included an eviction notice, a property seizure order, and a payment demand totaling $24,000 for alleged HOA violations and accumulated fees. I examined the documents with the practiced eye of someone who has reviewed countless legal filings. Within 90 seconds, I identified more than a dozen fatal legal flaws. The court formatting was wrong. The case numbers did not exist. The statutes cited were fabricated. Service procedures were improper. Judicial signatures were forged. Court seals were fake. The language itself was something no legitimate court would ever use. These weren't merely flawed documents. They were blatant forgeries to anyone with legal training. "Grandma, these papers are completely fraudulent," I said, keeping my voice steady so as not to alarm her further. "No court issued these. No judge signed them. None of this is real. You are not being evicted. Someone is trying to steal your house using fake legal process." She looked up at me, tears pooling in her eyes. "But they said they were from the county," she said. "They showed me badges. They told me that if I didn't pay or leave, the sheriff would come and force me out. Michael, I don't have $24,000. I don't know what to do." That cold judicial focus returned in full force. These individuals had targeted an elderly widow, used counterfeit legal documents, and invoked the authority of courts and law enforcement to commit fraud. They had crossed a line that implicated not just criminal statutes, but the inherent authority of the federal judiciary to protect the integrity of the legal system itself. I asked her to describe the men, what they wore, what they said, whether they left any contact information. She told me they were wearing black sleeveless tactical vests and claimed to be county property enforcement officers. Before leaving, they gave her a phone number to call if she wanted to arrange payment to avoid eviction. I dialed the number from my personal phone without identifying myself. A man answered, "County Property Enforcement. How can I assist you?" "This is regarding the eviction notice served at 2847 South Peoria." I said evenly, "I have questions about the legal authority for this action." He responded confidently, "That property has accumulated over $24,000 in unpaid HOA violations. The county has authorized eviction proceedings. Payment must be received within 72 hours, or the eviction will be executed by the county sheriff." "I see," I replied. "And which county court issued the eviction order?" There was a brief pause. "That information is contained in the documents provided to the property owner. All legal authority is properly documented." "Actually," I said, my voice shifting to the tone I reserve for attorneys who have made serious errors in my courtroom, "the documentation is fraudulent. The case numbers are fabricated. The court seals are forged. The judicial signatures are fake. I know this because I am a federal judge. And I have reviewed the documents thoroughly." I continued into the phone. "What you are doing is fraud through the use of fabricated legal process. Who am I speaking with?" The line went silent. Several seconds passed. Then, click, he hung up. I immediately called my chambers and spoke to my clerk. "I need the United States Marshal Service contacted right now." I said, "This involves fraudulent judicial documents being used to threaten my grandmother. I want this treated as a threat against a federal judge's family using fake court process." Within 45 minutes, 2 deputy U.S. Marshals arrived at my grandmother's home. I laid the documents out on the kitchen table and walked them through the defects point by point. When they realized the targets were an elderly woman and the family of a sitting federal judge, and that the perpetrators had used forged court orders, their demeanor shifted instantly. "Your Honor," Deputy Marshal Buchanan said, "using fraudulent judicial documents is a federal offense. Targeting a federal judge's family elevates this significantly. We'll coordinate with the FBI and pursue this aggressively." I then did something most people never have the authority to do. I exercised my federal judicial power, not by issuing a criminal warrant, but by drafting a civil contempt order addressing the ongoing misuse of judicial process. I wrote the order myself, citing my authority as a United States District Judge to protect the integrity of the judiciary and halt active fraud involving forged court documents. The order identified John Doe defendants operating in Tulsa County using fraudulent eviction paperwork and commanded them to appear before my court to show cause why they should not be held in contempt for forging judicial documents and abusing court authority. It authorized the U.S. Marshals to locate and serve the defendants. FBI Special Agent Quincy was assigned to the case. Using the phone number left with my grandmother, the FBI traced the operation to 2 men, Montgomery Drake and Thaddeus Boone. Both had prior convictions related to fraud. Within 18 hours, U.S. Marshals arrested both men and brought them into federal custody. Due to the obvious conflict of interest, I did not preside over contempt hearing. Another federal judge in our district, Judge Patricia Hawkins, handled the matter. The hearing was swift and devastating. Judge Hawkins reviewed the forged documents, testimony regarding my grandmother, and proof that the defendants had been properly served with the contempt order. "Mr. Drake, Mr. Boone," she said from the bench, "you used fabricated court documents to terrorize an elderly woman who happens to be the grandmother of a federal judge. You forged judicial signatures, created fake court seals, and invoked the authority of this court to commit fraud. This court finds you in contempt." She paused. "You are remanded into the custody of the United States Marshals immediately, pending criminal prosecution." They were taken straight from the courtroom into federal detention. The contempt ruling gave federal prosecutors the time they needed to build a comprehensive criminal case. Charges included wire fraud, elder abuse, forgery of judicial documents, and targeting the family of a federal judge. Because the crimes involved forged court documents and interference with the judiciary, the case was prosecuted federally. The U.S. Attorney's Office pursued it aggressively, emphasizing both the attack on judicial integrity and the deliberate targeting of a vulnerable elderly victim. The investigation uncovered a broader scheme. Drake and Boone had targeted 17 elderly homeowners across Oklahoma using the same fake eviction operation. They had collected more than $300,000 from victims who paid out of fear of losing their homes. But targeting a federal judge's grandmother changed everything. That invoked federal judicial authority in ways neither man had anticipated and clearly terrified them. The trial took place 6 months later in federal court. My grandmother testified about receiving the papers and the fear they caused. I testified regarding the legal defects in the documents and how they constituted blatant forgeries of judicial process. The prosecution emphasized that the defendants had forged federal court documents, a crime with specific, severe penalties, and had demonstrated contempt for federal authority by targeting a judge's family. The jury deliberated for 2 hours, guilty on all counts. Sentencing followed federal guidelines for crimes involving judicial forgery, elder abuse, and interference with the judiciary. Montgomery Drake was sentenced to 21 years in federal prison. Thaddeus Boone received 17. Beyond prison time, there was something else they would never escape. Federal judges do not forget attacks on the judicial system.